Imagine you're cleaning out a desk drawer and you find this ancient, unexpired coupon. But
Yes.
instead of saving you 50 cents on coffee, it's this hidden lever of power.
Right. Yeah.
It's a perfectly valid legal statute that's, capable of dismantling a systemic injustice.
Which is wild, and that is exactly what we're looking at today in this deep dive into a 2016 Smithsonian article.
Yeah.
We're talking about Reconstruction. So specifically, around 1872 and 1873, the D.C. Legislative Assembly passed these laws requiring equal service for any well-behaved customer, regardless of race.
Right. But then Jim Crow happens.
Exactly. When Jim Crow segregation took hold, those laws just completely vanished.
Wait, I need to stop you there. How does an entire government just lose a civil rights law? Did they, burn the archives or something?
No, they didn't even have to do that. You really have to understand how legal code works.
Okay.
The physical books that lawyers and judges reference every day, the DC Code, they're essentially just printed summaries of active laws.
Oh, I see.
Yeah, so when the code was reprinted in the early 1900s, the compilers just simply left those equal service laws out of the new editions.
So because the rule wasn't printed in the physical book sitting on the judge's desk, it just faded from public memory.
Precisely. The laws were never officially repealed by a vote or anything. They were just aggressively ignored for over 70 years.
Wow. But if the law technically still exists and no one believes it does, how do you force a judge to actually go dig up the original 1873 archives? You can't just send a polite letter to the court.
No, you definitely can't. You have to completely break the status quo. You need a test case. And in 1950, Mary Church Terrell provided exactly that.
Oh, wow.
She was 86 years old at the time. She was actually born the same year the Emancipation Proclamation was signed, which is amazing.
That is incredible.
Yeah, and a founding member of the NAACP. So she leads a mixed race group right into Thompson's restaurant on 14th Street in NW. They take their trays and they're denied service.
I've always wondered about the logistics of these historical protests. Did they just march into a random cafeteria? Why pick Thompson's?
Well, it was highly strategic. Thompson's happened to be right next door to the offices of the lawyers handling her case.
Oh, so the lawyers could practically look out the window and watch the incident unfold.
Exactly. And they needed that efficiency because the legal system fought back immediately. A municipal judge actually dismissed their first case on a technicality.
Really? On what grounds?
The judge argued that because the 1870s laws had been ignored for so long, they were essentially dead by disuse. Implied repeal, basically.
That sounds incredibly frustrating. We ignored the law, therefore it's not a law anymore. What do you even do when a judge tells you that?
You go get another tray of food.
Oh my gosh.
Yeah, that July, Terrell walked right back into Thompson's and got denied service a second time. This ensured a fresh case could be filed, and the legal battle wouldn't just die in a lower court.
That second tray of food is what sparks the chain reaction, right? This localized cafeteria dispute goes all the way up to the Supreme Court.
It does. It culminates in the 1953 case, District of Columbia versus John R. Thompson, Inc., and the Supreme Court issues a unanimous 8-0 ruling declaring the lost laws valid.
Wait, unanimous. In 1953, how did they get every single justice to agree on desegregation a full year before Brown versus Board of Education?
It was all because of how the case was framed. The lawyers didn't ask the Supreme Court to strike down national segregation.
Okay.
They kept it hyper-local. They basically asked the court, did D.C.'s local government have the authority to pass those laws in 1873, and were they ever legally repealed?
So by focusing purely on local D.C. jurisdiction rather than setting a massive national precedent, the court could easily agree on the legal mechanics.
Exactly. A valid law is a valid law.
Which instantly ended segregation in all D.C. dining establishments. And the source material notes that Terrell actually returned to Thompson's after the verdict, and the same manager who had previously turned her away personally escorted her to a table.
Yeah, the ripple effect was immediate. D.C. movie theaters and other businesses quickly desegregated themselves shortly after.
Voluntarily.
Yeah, they saw the writing on the wall. They wanted to avoid facing similar lawsuits, realizing the legal landscape had fundamentally shifted back to 1873.
That is wild. And for you listening, this history is still hiding in plain sight. Next time you walk past the CVS on 14th and New York Avenue in D.C., remember you aren't just passing a drugstore.
Exactly.
You were standing exactly where a forgotten law was brought back to life by an 86-year-old powerhouse.
It makes you wonder, if fundamental civil rights laws could simply be left out of the books for 70 years, what other forgotten rules might be hiding in our legal history today, just waiting for the right person to test them?